Well, people, we are actually on time, so we've got time for another couple of questions that have come in. Alan, I think you might be able to help with these. As we enter the new economy, are there any specific amendments to our terms and conditions we should make to protect the company and its clients?
Well, yes is the answer to that. Your terms and conditions should be reviewed periodically every year, regardless of global pandemics and whatnot, just to make sure that they still fit the type of business that you're doing and the business practices that you're doing. So we should have a think about what is contained in our terms of business in terms of passage of title, passage of risk, terms for payment, what constitutes a breach of contracts, things that we maybe hadn't considered would before but do now. The definition of force majeure is one that we have to think about a little bit more clearly, because we tend to think of hurricanes and ash clouds. We learned about ash clouds about 10 years ago, and pandemics and the definitions of virus spreads are now things that should be considered as a force majeure, regardless of who we want to blame, be it a 5G company in China or whatnot. But I'll come back to terms and conditions just when I talk about something else maybe later on. But yeah, I think your terms and conditions need a regular MOT, is the way I would describe it. Maybe not on an annual basis, but think about the type of work that you do, and if that has changed in any way, how that may affect your terms and conditions. That's my thoughts.
And while you're there's a second question for you. What protections are in place for businesses we transition into a return to work? There are some issues which have been caused by COVID-19 and the restrictions, and I've heard about some measures being proposed to assist.
I touched on this briefly because it was coming down the line. It's now in force, which is the Corporate Insolvency and Governance Act, which is a wonderful piece of legislation designed to help everybody in business as we come back through. Before I go on to talk about some of the great things that will do to help, obviously the Chancellor announced very helpfully an incentive payment to businesses for when staff return from furlough, so allows you to receive a cash payment. So that will certainly help cash flow and help business. The reduction in VAT for the hospitality and tourism markets will certainly be of assistance as well. So the government are thinking about us, UK as well as Scottish. Of course, the Scottish government introduced phase 3 yesterday, which was very welcome, with openings of restaurants and bars and sort of places of worship, various things that allow us to get back to, or further down the path to return to business. Going back to this new piece of legislation, it's very helpful for businesses, and it provides a bit of relief from some of the things that we worry about, or we have to worry about, and it takes a little bit of the pressure off because we haven't been trading in normal circumstances. So from the very benign, or not benign, but the one that doesn't involve creditor pressure or other worries, is companies' house filings. There's been extensions permitted to when you have to file your various documents at Companies House every year, which is very, very helpful. It takes an administrative burden off. So the minute you come back into the office, you're not hit with fines and difficulties for not being able to do all the things that you couldn't do when you were in the office. So extensions range from 42 days to 12 months in some circumstances. So if you're in any doubt, maybe speak to your accountants or your bookkeepers just as to what, or indeed your lawyers who maybe look after these sorts of things for you. But there are extensions available, so you're not caught out with timescales and fines at the time where you least require it. Other things that are available, there are going to be very few businesses who haven't been impacted financially by the crisis and the pandemic, whatever we want to call it. But there's a number of tools available to businesses which weren't there before with regards to, I don't want to use the word insolvency because it's the wrong word, it is solutions and recovery solutions. So the new Act brings into to play a number of tools that we can use for businesses to get a little bit of breathing space and to stop things that would happen ordinarily from happening. So one of these examples brought in by the Act is a company moratorium. Now, a moratorium is something that prevents people from enforcing things against you. So a company can ask for a 20 business day moratorium whilst they have a look at how they want to restructure, how they need to deal with perhaps some debts, and you would appoint a monitor. Now, the monitor will be an insolvency professional or turnaround professional, and what it will allow you to do is to get a little bit of time just to assess what changes need to be carried out by your business, and that 20-day period can be extended for a further 20 days if you're not quite ready to get back into the saddle, as it were, and it can be extended further by the court. Another really helpful thing is I should say with the moratorium, the directors will always remain in control of the business in this period. So very different to administrations and other things where moratoriums are granted. You're being monitored by a professional, but you're still in control of the business. A restructuring plan is introduced as well. People may have heard of CVAs, and the idea here is that there's a less formal, but every bit as effective, ability of a business to put together a plan specifically designed for post-COVID matters, to say, well, okay, we've got all of this money that we owe and we're behind the 8 ball in terms of not being able to trade. Here's how we propose to do this over a slightly extended period, and you can put these proposals out to your creditors, and there's a voting process whereby it can be approved by 75% of your creditors. What is very helpful about this is that there are no financial entry conditions, so you don't actually have to be insolvent to do this. So if you can just look forward and say, well, it might be a little bit of cash flow issues. I'm not quite insolvent. I don't think I am, but you can just go to your creditors and basically put a proposal to them. And the court holds final approval. So even if you don't quite get your 75, you can go to the court, and the court can say, well, that's not quite the voting numbers that we were looking for, but it's just inequitable, and you can make your case there. So they're two very useful breathing space apparatus, which I think that they've been brought in by legislation. Statutory demands and winding up petitions, two horrible things that you never want to get, but your creditors might, in the ordinary course, want to enforce any monies that are overdue. There's presently a suspension on the service of a statutory demand, and a creditor cannot petition for the winding up of your business. There was a suspension period commencing on the 27th of April. Originally, it was thought to be until the end of June, but or 1 month since the Act came into force. The Act is now in force, and therefore we really have a bit of a stay of execution in terms of any petitions lodged if the debt has come about as a result of the COVID crisis until the end of July, effectively. And any statutory demand served upon your business between the 1st of March and the 30th of June cannot be relied upon to put you out of business. So two useful tools to get proactive, and a little bit of a shield in terms of what can be done to you. A really helpful one is, I suppose, depending if you're a supplier or receiver of certain things, is supplier termination clauses. There has always been, or there has already been, a requirement for utility providers to continue to supply if you pay for it, and if you're going through some sort of restructure, moratorium, intention to appoint administrators, that sort of thing. That was for key utility suppliers, your gas, your electricity. There is now a prohibition on suppliers for stopping supply of services by reason of potential insolvency. Now, most suppliers will have provision in their terms and conditions which say we don't have to serve you anything if you try to make an agreement with creditors. Any form of insolvency or informal debt solution, they can just down tools and stop giving you services. They're now prohibited from doing that. As long as you're still paying for the services, then they can't stop supplying you, and they also can't amend their terms and conditions to add more punitive costs or penalties, or increase the cost of providing the services by virtue of this. So again, if you're going to try and trade out of something and recover and get back onto your feet after a period of hiatus, then having essential supplies of services, and your suppliers just can't cut you off at the knees, which again is very helpful. And finally, I'd mentioned, and very briefly, the suspension of wrongful trading concerns is for the period from the beginning of March now, effectively till the end of June, and extended to July. Then you can, where you would otherwise as a director have to think, oh my gosh, we're in financial difficulty here and have to behave a little bit differently. There's a suspension on your behaviour a little bit if you can justify it as being trying to rescue the business through the restrictions that you've got. Unprecedented times is the buzzword in my field throughout this period. So there are some really, really helpful, I think, really practical solutions so that, you know, when you open the door again to the brave new world, you're not attacked by 3 or 4 different things. So there's some positive things that you can do. There's some checks and balances there, and there's some shielding, and all of it is really, really positive. And I'd be happy to talk to any businesses who have concerns.
Great.
Okay.
All right. Thank you.